Good morning. Thank you everyone so much for joining us today. We appreciate you spending your morning talking with us today about donor disclosure and donor privacy. On today's call, we are going to discuss a recent court ruling from the Supreme Court, Americans for Prosperity Foundation versus Bonta, state legislative activity on donor disclosure and privacy policy, arguments around disclosure versus privacy. We'll hear about another court case, and then we'll talk about HR 1. Here today with me to discuss all of this is our managing editor, Corey Ugalito. Thank you so much for joining me today, Corey.
Yep, thanks.
Perfect. So first, can we start off by talking a little bit about this month's Supreme Court ruling?
Yeah, sure. So start with the background of Americans for Prosperity versus Bonta. The case involved a California law that required nonprofits to disclose their donors' identities to the state's attorney general by requiring nonprofits to file copies of their IRS 990 forms with the states. Those IRS 990 forms are financial reports that are required under federal law, and they collect the names and addresses of donors contributing in excess of $5,000 to a nonprofit in a given tax year. Although the California law did not provide for public access to the Schedule B information, court documents showed that inadvertent disclosures of the Schedule B information did occur. So in 2014, Americans for Prosperity Foundation challenged the law in U.S. District Court, which triggered a series of legal developments over several years. In 2016, Judge Manuel Real found in favor of Americans for Prosperity and barred California from collecting the group's Schedule B information. Real separately reached a similar ruling in a case involving the Thomas More Law Center, which is a different nonprofit group, and then those cases were combined on appeal. In 2018, a three-judge panel of the U.S. Court of Appeals for the Ninth Circuit unanimously overturned that lower court's ruling. Judges Raymond Fisher, Richard Paez, and Jacqueline Wynn issued the ruling. Fisher and Paez are Clinton appointees, Bill Clinton appointees, and Wynn is a Barack Obama appointee. This appellate panel upheld California's disclosure requirement upon finding that it, quote, serves an important governmental interest. The plaintiffs then appealed the Ninth Circuit decision to the U.S. Supreme Court, which heard oral arguments on April 26th of this year, and then on July 1st issued a decision. So on July 1st, the U.S. Supreme Court issued a 6-3 decision reversing the Ninth Circuit's ruling, striking down the California law in question. Incidentally, in this term, the U.S. Supreme Court reversed 15 of the 16 appeals that it heard from the Ninth Circuit, more than any other circuit. They're not the highest rate. Chief Justice John Roberts penned the majority opinion. In it, he said that, quote, California has an important interest in preventing wrongdoing by charitable organizations, end quote. But he went on to say that there was a dramatic mismatch, his words, between that interest and California's donor disclosure requirement. He wrote, quote, the upshot is that California casts a dragnet for sensitive donor information from tens of thousands of charities each year, even though the information will become relevant in only a small number of cases involving filed complaints. In reality, then, these are Robert's words, California's interest is less in investigating fraud and more in ease of administration. He said that interest did not, quote, reflect the seriousness of the actual burden that the demand for Schedule B's imposes on donors' association rights. Justices Thomas, Alito, Gorsuch, Kavanaugh, and Coney Barrett, all appointed by Republican presidents, concurred in the judgment. Justices Alito, Gorsuch, and Thomas declined to join some parts of the majority opinion, disagreeing about whether an exacting scrutiny or strict scrutiny standard should be applied in cases like this. Under the exacting scrutiny standard, a law that infringes upon a constitutional right will be upheld only if it is narrowly tailored to advance a compelling governmental interest. The strict scrutiny standard, which is more stringent, requires that a challenged law be narrowly tailored, using the least restrictive means available to serve a compelling government interest. In the majority opinion, Roberts reasoned that the exacting scrutiny standard should be applied to all cases of this type. Alito said that he was, quote, not prepared at this time to hold that a single standard applies to all disclosure requirements. Gorsuch joined Alito in that opinion. And then in his concurrence, Justice Thomas argued that the court should have invoked the strict scrutiny standard because, quote, our precedents require application of strict scrutiny to laws that compel disclosure of protected First Amendment association. Justice Sonia Sotomayor wrote a dissent, joined by Justices Breyer and Kagan, all Democratic appointees on the court. Sotomayor said that the majority opinion, quote, discards the decades-long requirement that to establish a cognizable burden on their associational rights, plaintiffs must plead and prove that disclosure will likely expose them to objective harms, such as threats, harassment, or reprisals. She added, the evidence shows that California's confidential reporting requirement imposes trivial burdens on petitioners' associational rights and plays a meaningful role in the state attorney's ability to identify and prosecute charities engaged in malfeasance, which she said is, quote, more than enough to satisfy the First Amendment. So, a lot going on there.
Yes, certainly. It sounds like from that court ruling that this policy area is pretty contentious. Could you explain a little bit why that is?
Yeah, part of it is because nonprofits can and do engage in political activity. Most commonly, 501c4 groups, which are defined as political education organizations, can engage in political lobbying. This includes donations to political committees that support or oppose ballot measures, bond issues, recalls, or referenda. This kind of political activity is referred to as issue advocacy. However, C4 organizations are not allowed to advocate expressly for the election or defeat of particular candidates. So I'll just plow straight into what the arguments then are around this topic. And first, to address that, we need to break down the issue a little bit further. So historically, we've talked about donor disclosure as a single policy area, but as the issues evolved, there are really two perspectives and policy goals. On the one hand are those who advocate for what they say is increased required donor disclosure. And on the other hand are those who advocate for what they say is increased protection of donor privacy. So on the side supporting expanded donor disclosure, they tend to make the following types of arguments and claims. One is that disclosure ensures the accountability of nonprofit organizations and prevents fraud and corruption. They argue that disclosure limits the political influence of major donors who might otherwise use nonprofits to advance their private interests. They argue that exposure of government-held confidential donor information is rare, and the risk of that information being exposed to donors and nonprofit organizations is low. They argue that disclosure is necessary to prevent foreign influence in politics and elections. And they argue, among other things, that disclosure and donor visibility actually benefit nonprofits as endorsements of their missions. On the other hand, others favor donor privacy provisions based on the following claims. They would argue that forced donor disclosure violates free speech rights, and we saw the First Amendment come up in a recent Supreme Court decision. They'd argue that donor disclosure violates donors' rights to free association and privacy, that disclosure can lead to donor harassment, backlash, or retaliation, that inadvertent disclosure of confidential donor information by governments does occur, and that this compromises donors' rights, and that government has other tools at their disposal to ferret out fraud and protect the public against nonprofit fraud and corruption.
Cool. Thank you for that background, Corey. Now can we shift a little bit and talk about some of the legislative activity that we've seen so far this year?
Yeah, sure. And I'll try and get my mic a little bit closer. Hopefully I'm not like screaming right now. Sure. So far this year, state legislators have introduced at least 39 bills that touch in some way on donor disclosure and privacy policy. Of these 39 bills, 11 have been sponsored by Republicans, 17 by Democrats, and the rest by either bipartisan groups or committees. We can also break down the total number of bills by their position on the disclosure versus privacy split that we talked about a second ago. Of the 39 bills that we're tracking, 17 focus mostly on privacy and 22 focus mostly on disclosure. 5 bills on this topic have been enacted this year. All are primarily concerned with the privacy side of the argument. All 5 of these bills also were passed in Republican trifecta states, where Republicans control the governorship and majorities in both chambers of the state legislature. 4 of these bills were substantially similar, although there were some details varying between them. And those were passed in Arkansas, Iowa, South Dakota, and Tennessee. All 4 of these bills prohibit public agencies from doing the following. 1, requiring a tax-exempt nonprofit to provide a public agency with personal information about its donors, members, supporters, or volunteers. 2, requiring individuals to provide personal identifying information about their involvement with nonprofits. 3, publicly disclosing any personal information a public agency might possess. And 4, requiring a current or prospective contractor to provide a public agency with a list of the nonprofits that the contractor has supported. The bills do not bar public agencies from releasing personal information about nonprofits, donors, supporters, etc., pursuant to an active law enforcement investigation or a lawful warrant, subpoena, or other court order. The fifth major enacted bill, also in South Dakota, prevents executive agencies and officials from requiring nonprofits to make disclosures beyond those already required under state and federal law. That scope is a bit narrower than the bills we just talked about, but it's still similar.
Perfect. And can you tell me a little bit about where these bills are being passed and where they're being talked about in state legislatures as well? Is it kind of spread out all over the country?
Yes, though I need to pause for just a moment because that seemed to get cut out of my notes. So just give me just 1 second. I can be able to revise this pretty quickly. Okay, so legislative activity then has been concentrated in 18 states. 11 donor disclosure or privacy bills have been introduced in New York this year. So that's 28% of the nationwide total. There have been 3 relevant bills in Iowa and West Virginia. And then in 7 states, there have been 2 bills: California, Illinois, Nebraska, North Carolina, Rhode Island, South Dakota, and Tennessee. There's been 1 bill in 8 states: Arkansas, Idaho, Maine, Missouri, Montana, New Hampshire, Pennsylvania, and Wyoming.
Perfect. Thanks, Corey, for jumping around and finding that.
No problem.
Can you tell me a little bit about how this year's legislation compares to previous years? I know we've been tracking some of this information for a little bit in Disclosure Digest.
Yeah, sure. So it's actually legislative activity in this space has actually decreased somewhat compared to previous years. During the same 6-month period in 2019, we tracked 72 donor disclosure or privacy bills, 13 of which were enacted. In 2020, there were 47 bills and 4 were enacted. And as I mentioned a moment ago, we tracked 39 this year and 5 have been enacted. In the first 6 months comparatively of 2019, 2020, and 2021, Democrats have sponsored more disclosure or privacy related bills than Republicans. In 2019, Democrats sponsored 34 to Republicans 21. In 2020, Democrats sponsored 22 to Republicans 13. And this year, the gap has narrowed. Republicans have sponsored 11 bills to Democrats 16.
Perfect. Thank you. So pivoting back to something we alluded to at the beginning of the call, we were talking about the other court cases that we've seen going on in this donor disclosure, donor privacy space. Can we talk a little bit about those other cases?
Yeah, so it's going to be interesting to see how the recent Americans for Prosperity case bears on other cases that are currently working their way through the lower federal courts. One is a case called Gaspee Project versus Medeiros. The plaintiffs are 2 nonprofit groups, the Gaspee Project and the Illinois Opportunity Project, which are both 501c4 groups that I talked about earlier. They allege that a Rhode Island law requiring issue advocacy groups to disclose personal information about their donors violates donors' free speech and privacy rights. The law in question was enacted in 2012. It requires issue advocacy groups to disclose to the public personal information about donors who contribute more than $1,000. Groups must report the donor's name, job title, employer, home address, and donation amount. And then this information is posted to a government website. The law also requires that in the weeks leading up to an election, groups publish the names of their top 5 contributors on any advertising or messages. On August 28th, 2020, Judge Mary McElroy, a Donald Trump appointee, dismissed the lawsuit. She said, quote, "The Act's disclosure and disclaimer requirements are justified by the sufficiently important state interest of an informed electorate, and any burdens on political speech that they may cause are substantially related to that state interest. The plaintiffs therefore cannot state a plausible claim that the Act is facially violative of First and 14th Amendment rights." The plaintiffs appealed that dismissal to the U.S. Court of Appeals for the First Circuit, which heard oral arguments on June 9th. The judges deciding the case are David Barron, a Barack Obama appointee, Bruce Celia, a Ronald Reagan appointee, and Pedro Delgado Hernandez, another Obama appointee.
Perfect. Thank you for that overview of other court cases going on. Now, I think there's also some federal legislation that's happening in this policy area. you mind giving us an overview of that quickly, Corey?
Yeah, sure. HR 1, which is the election policy omnibus bill passed by the US House back in March, contains provisions that would increase donor disclosure requirements for corporations, unions, and nonprofit groups that make expenditures in federal elections. Under HR 1, any covered organization, such as a corporation, labor union, or 501c nonprofit, that spent more than $10,000 on campaign related expenses in a federal election cycle would have to regularly file campaign finance reports that included the following information. One, the organization's name and principal place of business, and then a corporation would provide a list of its owners, including their names and addresses. Two, the amount of each campaign related expenditure exceeding $1,000, including the name and address of the recipient. Three, a certification by the organization's chief executive officer that campaign related expenditures were, quote, not made in cooperation, consultation, or concert with, or at the request or suggestion of a candidate, authorized committee, or agent of a candidate, political party, or agent of a political party. And then four, for all donors contributing $10,000 or more in an election cycle, the name and address of the donor, the date and amount of the contribution, and the aggregate amount given by the donor during the election cycle covered in the report. Organizations would not have to disclose contributions from donors who specify that they do not want their donations used for political purposes. And HR 1 would also suspend these reporting requirements, quote, if the inclusion of the information would subject the donor to serious threats, harassments, or reprisals. Now, although this bill has cleared the US House, it's unclear whether it stands a realistic chance of passing the US Senate, where Democrats have a 50-50 majority and Vice President Kamala Harris can break a tie. Senator Joe Manchin, the Democrat from West Virginia, has said he does not intend to vote in favor of HR 1 as drafted. And Manchin has also indicated his opposition to ending or reforming the filibuster in any way to facilitate passage. On June 22nd, the Senate voted 50-50 to allow debate on the bill, which was less than the 60 votes they needed to proceed. But Senate Majority Leader Chuck Schumer has said he will bring the bill up for debate again later this summer.
Awesome. Thank you so much, Corey. I appreciate you taking us through that deep dive on all things to do with donor privacy and donor disclosure. If this policy area interests you, we highly recommend subscribing to our newsletter that I mentioned earlier, the Disclosure Digest. We'll be sending out a link to subscribe with a copy of this briefing and an email that you guys will get tomorrow. If you have additional questions that we didn't answer, please send us an email to editor@ballotpedia.org. And then finally, we certainly appreciate all of our supporters who make Ballotpedia happen. If you enjoyed this today, we recommend considering donating. You can do that at ballotpedia.org/donate. Thank you everyone so much for your time, and thank you, Corey.
Thank you. Have a good one.